Bit of a serious one today. You may remember that story recently of the guy who stabbed the people but was given a hospital order after the Crown Prosecution Service accepted pleas to manslaughter on what we call the grounds of diminished responsibility. Yet he was also convicted of attempted murder, several counts. And the argument was, well, because what we call the mens rea, that is the mental element of attempted murder, is you intend to kill and you have the capacity to make that decision, how can that be consistent with then saying, well, he didn't have the mental capacity to commit actual murder? Well, the reason for that is just the long and tortuous history of how we deal with people who suffer from mental problems and what responsibility we put on them for committing crimes. So just to explain, before the abolition of the death penalty, if somebody was convicted of murder, then they were hanged. This was in England and Wales. Scotland actually did have a slightly different procedure. But the courts recognised, there'd always been recognised that some people just didn't quite know what they were doing. So in the 19th century, a guy tried to assassinate the Prime Minister. Now, as it happens, he got the wrong person. But he was put on trial. But they sort of decided that clearly this was somebody, he just wasn't thinking straight, to use a non-psychiatric diagnosis. And they introduced something which was named after this guy called the McNaughton test, sometimes pronounced McNaughton, and there are various spellings even in the law reports, and nobody seems quite sure what his actual name was. But that basically introduced a test which was, you could find somebody not guilty by virtue of insanity if, and I'll read this, and I've got the light shining on my eyes, so this is quite hard to read. At the time of committing the act, the accused was under such a defect of reason from disease of the mind as to not know the nature and quality of the act he was doing, or if he did know it, that he did not know he was doing wrong. And that became the standard test. If you could meet that burden, and the burden was on the defence, it was on the defence to prove that. It wasn't for the prosecution to prove somebody was sane. It was for the defence to prove somebody was insane. If they met that test, then they avoided the gallows and they were committed to life imprisonment instead. But that was it. There was no halfway house. You were either completely insane or you were guilty. And like I say, that was different in Scotland. In Scotland, a jury could always return a verdict of culpable homicide, which is sort of their equivalent of manslaughter. And that's where we get into some difficulties with terminology. You see, manslaughter can be committed in lots of different ways. The offences of manslaughter, there's all sorts of different ones. Like, say for instance, I am reckless and my reckless actions cause the death of somebody. Then I am guilty there of reckless manslaughter. But that covers everything from I take a swing at somebody just intending to punch them but not commit serious harm, but they fall over and they bang their head and they die. The mens rea, as we said, for murder is at the time you inflict the act, you must have intended to kill or to commit serious harm. And, just pushing somebody or swinging a punch arguably doesn't meet that test. So you fail on the mens rea element, but you are still guilty of manslaughter. But that's one where you don't have the intent. However, after sort of much cutting and going backwards and forwards, and actually my one House of Lords case, as it was back then, was all about this issue. It was actually about what we call provocation and whether that reduced murder from manslaughter and what exactly was the test. The funny thing about that is, due to sort of certain mix-ups, I was the person who went to collect the judgment. You actually do that in the House of Lords itself. You walk into the chamber and you cannot hear anything in there at all. The acoustics are terrible, but luckily they tell you in advance what the decision is. That was rather embarrassing, and I'll tell you why in a moment. But due to some mix-up, my name, even though I was led by a silk and a very senior junior, my name ended up actually on the law report due to an administrative mix-up. But the funny thing is, the House of Lords, obviously, that's the final decision maker. But shortly after that decision, they actually overruled themselves and said, actually, we got that wrong last time. So my one House of Lords victory lasted about 18 months. The most embarrassing thing about that is, when I was in the robing room getting ready, they give you the judgment in advance. And I, of course, just skipped to the end. And it said, for all the reasons above, we dismiss this appeal. And I was like, oh, never, yeah. So I was ringing the solicitor just to say, sorry, we're lost, when the very nice prosecutor came over and said, Alan, remember, this was our appeal, that means you've won. It's like, oh yes, because I'm so used to only appealing losses. Because in this particular case, the House of Law, the Court of Appeal had actually come down on our side, and it was the prosecution appealing to the Supreme Court. But yeah, this has gone through sort of lots of different iterations. But it was recognised that there needed to be a halfway house. And so, if just bear with me a second, like somebody brighter than me wouldn't be stood in front of a really bright light doing this. But yeah, they introduced something called diminished responsibility. And the test there is somebody suffering from such defect of the mind that they're not fully responsible for their actions. Now we look at it in terms of loss of control. So we accept that maybe they knew what they were doing, but for whatever reason, they couldn't stop themselves doing it. So say, for instance, somebody is under the delusion that they are being attacked, and they attack in what they think is self-defense. This is to be sort of something different from, I just misunderstood and somebody wasn't being aggressive, but I thought I was. This is something like, I thought, basically aliens or werewolves were out to get me. I thought they were aliens and werewolves, so that's why I took them out. Well, in that case, that is a defence to murder. However, we just call it manslaughter. The offence they are convicted of is manslaughter. Now, arguably, we'd avoid a lot of the confusion if we called it something, in the same way we say not guilty of murder through reason of insanity. If we said not guilty of murder through reason of diminished responsibility and called it something else other than manslaughter, that might actually, sort of clear up some of the confusion. But what actually happens if you are acquitted, either on the basis of insanity or diminished responsibility? Well, something still has to happen. And the court can impose what they call a hospital order. And a hospital order says you go to a secure hospital effectively until you are cured. And that's what happened in that particular case. Now, people think that's being let off lightly. However, you speak to a lot of people, and this is the whole plot of One Flew Over the Cuckoo's Nest, isn't it? That being sent to prison, if you get a life sentence, you'll get what they call a tariff. So it'd be like you serve, anywhere between 12 years and whole life. But, an average of, say, 22 years. At least you're getting out sometime. Whereas with the hospital order, you are locked up until you are deemed safe to be released. And if it's an untreatable illness, then you will probably never be released. And some people, there was one guy who years ago, he set fire to a pair of curtains in a children's home. And at the time they said, oh, he's clearly mad. So he was given a hospital order, and he ended up being one of the longest serving people in the UK, even though technically he was just on a hospital order, not a prison sentence. But he was locked up when he was about 14, and he was eventually released in his 70s for what effectively was just setting for criminal damage, although it was charged as arson, obviously. There's also now there are these new hybrid orders where a court can say, we find you didn't know what you were doing, so we're going to sentence you, we're going to send you to a hospital. However, if you are cured, you can then serve a sentence of imprisonment, and they will sort of put a tariff on that and say, and this is how long you should serve. Now, the argument is that's inconsistent. It doesn't make sense, because if you're saying somebody didn't know what they were doing at the time they committed the crime, well, what's the point of sending them to prison when they regain their sanity? Because, they're a different person, effectively. So it's fair to say that these these hybrid orders, they don't get used a lot. But yeah, like I said, this is all very confusing. And also, if somebody is convicted of an offence, they can later then be determined, to not be of sound mind and transferred to, say, Broadmoor or somewhere like that. You see, this happened with the Peter Sutcliffe, the Yorkshire Ripper. All the psychiatrists instructed by both the defence and the prosecution agreed. They said, this guy is insane within the legal definition. The judge, however, said, no, this is still going to trial. I'm not going to accept you just doing a deal. A deal. This guy has to go on trial, and we'll leave it to the jury. Because ultimately, jurors are the ultimate finders of fact. And jurors are told that they do not have to accept the evidence of expert witnesses, even where the expert witnesses are all in agreement. So Sutcliffe was convicted of murder. However, he did end up getting transferred to Broadmoor. One psychiatrist described Sutcliffe as, they said, this is an insane person who thinks he's a sane person pretending to be an insane person. But, a lot of his actions were cold and calculating. He did all this, oh, God told me to do it. But then he cleared up, after the crime scenes and stuff, and he went back to recover a banknote that he realised would be incriminating. So they were saying there that, well, all these actions, they're calculated and planning. This is not somebody who's out of his mind. But at the same time, we do recognise that merely because somebody is clever and cunning doesn't mean that they are sane. And that was the argument in this case. They said, yes, the guy clearly knew what he was doing and intended to kill, but he thought that he was being remotely controlled and that various people he were killing were, sort of aliens or plants or body snatchers and things like that. So that's what's happened to him. Now, the fact of the matter is, and I completely understand, why the family are aggrieved at this. Because apart from anything else, the prosecution are supposed to seek either the victim's views in a case where people survive, or the family's views in a case where they don't. They're not bound by those, of course, because a criminal prosecution is the state versus the defendant. Even surviving victims, they're merely witnesses. They're not parties to the case. But there is supposedly a victims' charter that covers all this. And arguably, there is something to say that perhaps the CPS could have been better in saying, look, this is what we're doing and this is why we are doing it. And also if they've explained and said, look, this guy is not getting out again for a very, very long time, if ever. But there you go. I hope you found that, sort of, as always, vaguely useful, vaguely interesting, because it is a sort of controversial subject that is, reviewed a lot. We've had, lots of things about, provocation being a defence, diminished responsibility. It used to be called, like loss of self-control, whereas now it's sort of like, just, it's a bit more nebulous than that. It's sort of, you might, because, by definition, you are controlling yourself if you're cunning and planning. Some people, just are loopy and they will just, stab somebody in public in full view of everybody. And arguably then, that's somebody who genuinely did, lose loss of control. It's all very complex, and ultimately, although expert evidence is admissible in terms of state of mind, the final decision makers are the jurors. So even in cases where experts agree, it is not, unusual, nor is it not permitted for judges to say, don't care what the experts say, let's see what the jury make of all this. So there you go. Today, I am in the old council chambers at the old county hall for Cornwall in Truro, for reasons that I won't go into, but I have some involvement with this. And I just thought I'd come in here today because I did want to go to some nice location for you to do some filming, but it's absolutely siling it down in there, and I thought my notes would get soggy. Although as it happened, I couldn't read them anyway because of this bright light in my face. You see, I think Stanley Kubrick's job is safe.